Hello folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. Today again we'll continue with the topic, the meeting of the board and its power. So as usual, we'll start with the quick revision of the topic that we have covered in the previous lecture. Right? We'll just give 2 minutes to that and we'll move ahead with the lecture today. So, what have we covered in the previous lecture? Yes, we understood the provisions of section 180 of the Companies Act 2013, right? And what was it? It is the restrictions on the power of the board. So prior to this we have also seen section 179, right? And we had discussed the various powers of the board and also that the requirement to exercise some of them specifically in the board meeting. Remember the entire section of 179 that we had covered? Specifically section 179 subsection 3, right? So beyond that we had 4 more powers of the board that could be passed only after receiving an approval from the shareholders, that too a special resolution, right? That means there are certain powers for which first the boards will pass a resolution, the board of directors will pass a resolution, and then the meeting of the shareholders will be called, right, and their approval will be sought on the same action, right, and that would be special resolution. So we had covered that there are 4 specific powers. First one is sale, lease or dispose of the whole or substantially the whole of undertaking. We had very well discussed the meaning of substantially, the meaning of undertaking, the meaning of net worth, and etc. We will not spend much of time on that and we'll move ahead, right? Next we had investing the compensation from merger and amalgamation. So if the board is receiving any compensation as a result of the merger or amalgamation, the purchase consideration that they receive, right, that money cannot be invested without the prior approval of the shareholders, right? Then we had borrowing of money. If borrowed plus proposed to be borrowed exceeds your paid up share capital and free reserve. This is actually one of the favorite points from the institute's point of view. If you look at the questions that you have been asked in the past, majority of the questions fall on this specific power of the board, right? So in today's lecture we are going to discuss the question answers based on section 180 that have been asked in your previous examination, right? So over there we'll deal with this topic a lot, right? So I would prefer we would revise this specific power in a little detail again, right? We'll just give a quick revision to that. So we are talking about borrowing of money. If borrowed plus proposed to be borrowed exceeds paid up share capital and free reserve. But this borrowing would not include temporary loans specifically, right? And what are temporary loans? We had discussed those are the loans which are repayable on demand or the loans repayable within 6 months of the date of the loan. But even though it is a short-term loan, even if it is repayable within 6 months or demand, but still if it is actually raised for the purpose of financing the capital expenditure, then we will not consider it to be temporary loan. That is another exception, right? That means if you are borrowing money for your capital expenditure, that will be included in your limits that we are checking, right? And I guess you all very well know the meaning of free reserve. These are those reserves which are available for distribution of dividend. But if you have any unrealized gain, any notional gain, money reserve that are created out of revaluing your assets, right, or due to change in the carrying amount of your asset and stuff, these are not profit that can be distributed as dividend, right? So these will not be considered to be part of free reserves, right? And there was one more important condition, that if you exceed the limit, right, then you have to pass a special resolution. Now the special resolution that the members are passing, that will be valid only if the members specify the amount, when they specify the next limit. For example, if your paid up share capital and free reserve sums up to rupees 100 crores, right, and you have already borrowed 80 crores and you want to borrow 20 crores, right? So total your borrowing already borrowed and proposed to be borrowed would exceed your paid up share capital and free reserve, right, and they would be exceeding it by 20 crores. So if you want to pass a special resolution to raise fund of 20 crores, then the special resolution would have to specify that the limit is extended to 120 crores. If they do not specify the limit, that will be considered as invalid. You cannot give a blanket approval to the directors, right? And one more point to be noted, that this power of borrowing can also be ratified in the shareholders meeting later. That means first you make the borrowing and then you can get it ratified in the meeting. If the shareholders do not ratify it, that would be considered as invalid, right? And if it is considered invalid, it will not be enforced by the lender. But that is only up to the situation where the lender is not able to prove that he has given money in good faith. So if the lender at any point of time proves that he has given the money in good faith and he was not aware about the limit, then he is very much eligible to get his money back, right? And on the other hand, if the directors use this money for the purpose of the company, for the benefit of the company, then the company would be liable. Otherwise, directors are personally liable to repay the money to the lenders, right? So the next that we had, the last power, is to remit or give time to directors to repay their due. So if the directors of the company themselves have taken any loan, right, and the due date has approached, the due date has been reached, and then they pass a resolution in the board meeting that okay, we are giving him an additional time of 2 years, that cannot be done, right? Because the board cannot misutilize its power. If that is the scenario, then all the directors will take loan and they will keep deferring their loans, right? So summing up the points, we had that if SR does not specify the limit of borrowing, the special resolution would be termed to be invalid. Unaffected rights and power of innocent buyers and in course of ordinary sale, right? There are two situations. The last is no reduction in the capital unless Act specifies. So we have discussed this already in the previous class. Now we'll move ahead. We will be covering the past year questions, right? So you will have to pay a little attention on this portion, because although the entire question will not be very useful for you, but still I will discuss the entire flow of the question, right? And you will have to catch the point. Okay, this is the twist. This is the important aspect from the provisions that you have to remember, that you have to pay attention, right? There are very small little things that we fail to pay attention, that we at most of the times assume and skip, but you have to be very precise with your facts, with the provisions, right? Because otherwise, if you are not very clear, not very precise with your provisions, you will definitely be confused in your examination. If your concepts are not very clear, if you don't know the cause behind it, you may be confused in the examination. So while we are discussing the questions, we'll come across few questions that would be confusing, right? But since we are discussing it now in the class, you will not face any problem in the examination. So while we are discussing the questions, we will follow the chronological order of the questions, right? In the pattern they have already appeared in your past examinations. So first we'll start with the year 1998, CA Final May 1998. So as I have already discussed in the class, that the majority questions that you have been asked in your examinations basically focus on your third power, that is section 180 subsection 1 clause C, right? So what have been asked in this question, I would read out the facts to you, right, and then I would discuss the answer. So as per the fact, there was a company, right, ABC Limited or XYZ Limited, whatever name you take. That company had a paid up share capital and free reserve summing up to rupees 100 crore, right? And the shareholders, they have passed a special resolution and authorized them to borrow money beyond the limit of paid up share capital and free reserve, right, for the specific purpose for which the SR is need to be passed. Because within the limit, they can just pass a board resolution and borrow the money, but once the limit is exceeded, they need an SR. So they have validly passed a special resolution, right, in the general meeting. So the board of directors, they have borrowed the total amount of 130 crores. So your limit was 100 crores and they have borrowed 130 crores. But out of this 130 crores, right, you have segments. Your 20 crores are short-term loans. So you remember, short-term loans are basically temporary loans that we had discussed, right? and 25 crores are another temporary loan, right? But they have been borrowed for financing your construction, right? That means for capital. And the question says examine the validity. So you all remember how do you start the answer in your CA final law paper? When you are writing any answer, you will first have to specify the provisions of the section for against which the question has been asked. So over here we'll specify the provisions of section 180, right? And to be more specific, we will specify the provisions of 180 subsection 1 clause C, because this question specifically deals with the third power, that is about the borrowing, right? So if you remember the clause number as well, that would be very good for your examination, and that would create a good impression, right? And on a bang it will let the checker or the examiner, right, know that you have given the right answer, you have hit the right target, right? So remember one thing, whenever you get a question based on this particular provision 180 subsection 1 clause C, borrowing, you will have to write the entire provision, right? That if you are borrowing, if your money already borrowed and proposed to be borrowed exceeds your paid up share capital and free reserve, you will have to get the approval of the members in the general meeting, right? But over there temporary loans will not be included. And what are temporary loans? Even that you will specify, right? The short-term loan and the loan repayable on demand and within 6 months, whatever it is. And also that the temporary loan will not include the fixed capital expenditure loan, right? Or the loan that is taken for the purpose of financing the expenditure which is capital in nature, right? So after giving the entire provision of the act, you would go on to specify the case given in the question. So you will write down the case again in your answer. You'll go about with, okay, they have paid up share capital and free reserve worth rupees 100 crores, right? The directors want to borrow rupees 130 crores, out of which 20 crore is your temporary loan, hence it will not be covered. And you will also write that you are assuming that it is being borrowed in the ordinary course of business, right? And then you would include that this amount of 130 crores also includes 25 crore, which is actually for financing the capital expenditure that has been borrowed for financing capital expenditure. So it will not be categorized as temporary loan, hence it will be included in the limit, right? Then you will specify that the board of directors can pass a resolution to borrow the money only up to the limit of paid up share capital and free reserve, that is 100 crores. But if they want to go beyond, they will have to pass a special resolution. So in this case, they will have to pass a special resolution, and they have validly done that, right? They have passed a special resolution. But then you will also mention that the special resolution has to also specify the amount, right? The next limit of borrowing. And if it is not so, it will be termed invalid. And in the given question, they have, although they have passed a special resolution, they have not specified the limit, hence the special resolution is invalid. And if the special resolution is invalid, then the borrowing made by the board of directors is a violation to the provision of section 180 subsection 1 clause C, right? You understand? So this is basically the question that is majorly asked in your examination. If you get a question from section 180 subsection 1 or section 180, then assume that you are going to get this question, right? So you know what all things do you have to write in your examination. So next, in CA final June 2001, you had been asked a question on the same section, that is 180 subsection 1 clause C, right? But again there was a little add-on, and that is what we need to discuss, right? So in that given question also, the board of directors, they had passed a board resolution, but here they have not passed a special resolution yet, right? So the amount they have borrowed is 15 crores, right? And the other details of the paid up share capital, reserves, loans, etc., they are given in a chart format. So your share capital is 5 crores, reserve and surplus is 5 crores, secured loan is 15 crore, and unsecured loan is 5 crore. That is the only information given. So what do you understand with that information? That your paid up share capital and free reserve adds up to 5 plus 5, 10 crores. That's right. And what is the borrowing you already have? That is secured plus unsecured loan, 15 crores and 15 crores, sums up to 20 crores. So you have already exceeded the limit, and you further propose to borrow rupees 15 crores, right? So you need to pass an SR. That's very clear now, yeah? So you will have to specify that if there is any borrowing, and in the confirmation of this, that will be termed as invalid, right? So you will have to pass an SR in the general meeting. But in the question you had one more point, that one of the shareholders, one of the director actually, he opposed the said borrowing. He said it is not in the interest of the company, right? That is also one case given in the question. So what will the board do? They will pass a special resolution to get the approval to buy this, to borrow this 15 crore rupee. They have other way around also. They can borrow the money first and then they can ratify it in the general meeting also. So in this question again, first of all you had written the provision, then you have given the case. Now you have to give a conclusion. But if you notice, then in the question you have not been asked a lot of detail. The only thing they have said is that the company seeks your advice on the following. They have given some facts, company seeks your advice. So this is actually a very dangerous question for you. When they say the company seeks your advice, you will have to give in all your knowledge that you have. When somebody has come for your advice, just give it all your shot. This is all I know, please keep it. Whatever you want to do from this, please do it. So you have told them that you can pass a special resolution. If you have not passed a special resolution and still you have borrowed the money, you can now ratify it in the general meeting. Now again you will have to specify that if they ratify it, well and good, everything is okay, you can go ahead. But if they do not ratify, right, then the borrowing would be invalid. And what would happen in the case of invalid? The lender would not be able to exercise any right on this lending unless he proves that he has given money in good faith and he was not aware of the limit, right? And again then you have to go further and again elaborate that if this money, if the lender proves that he is in good faith, then the directors are personally liable. But if that money is used for the benefit of the company, then the company would be liable for the same, right? Because it has been borrowed and it has been used for the company. So you cannot say that it is the fault of the director and the company is not aware of it. The company is very well aware of it. The company is using that fund. The company is equally culprit now, right? And for this you can also refer to a case study that has been given, which belongs to the Lakshmi Ratan Cotton Mill Company Limited versus JK Jute Mill Company, 1957. And then you will again add on the last line that the directors may be held personally liable in damage to the lender on the ground of breach of implied warranty of authority, right? So whenever you are asked to give an advice, you will have to specify everything you know, which is relevant for the answer. So next question that we'll be discussing is from CA Final November 2004, right? Now again in 2004 you have been asked a question on the same topic. They hit the same point, 181 subsection 1 clause C. But now again there's a twist. Now what twist you have over here is that you have been provided a data for the past 3 years about the paid up share capital, the general reserve, the debenture redemption reserve, the secured loan, net profit of the year, everything, right? And then they say that the meeting of the board that has been called is to discuss the agenda of borrowing money. Enough. Now based on that information, advice. That is it. That is the end of the question. Nothing. They have not passed anything. They don't talk about borrowing money and anything. They just say that the board meeting has an agenda of discussing the amount to be borrowed. Now what do you have to specify is the maximum amount that the board can borrow without the approval of the shareholders, right? So when you start, as we have discussed, what do you write? You write the provision of the act, you write the provision of the section. So you jot down everything, that okay, the board resolution, the special resolution, the temporary loan, what are temporary loan, what are not considered temporary loan, everything you will write down, right? Then you will come down to the case. And if you see, then you have been given data about your paid up share capital, your general reserve, debenture redemption reserve, secured loan and net profit. So keep it in mind that debenture redemption reserve is specifically for the purpose of redeeming your debentures. You cannot declare dividend out of it. So they are not your free reserves. So they will not be included. So what will you consider basically is your paid up share capital and the general reserve. And what year will you consider? Exactly the latest year. You have no business with what had happened in the past, because over here we are not talking about the average. We are just talking about the paid up share capital and free reserve that you have on the date, right? So your paid up share capital and free reserve, they had a limit for, let's say it is 1 crore 35 lakhs, right? And then you have also been given data about the secured loan. That means the borrowing has already been made and the limit for that has been specified as 30 lakhs. So 1 crore 35 lakhs minus 30 lakhs, you still have a limit remaining for 1 crore and 5 lakhs. So you will write that since the board have called a meeting, they can raise the loan up to the limit of 1 crore 5 lakhs. They do not require a special resolution. So they themselves can borrow the money amounting to rupees 1 crore 5 lakhs, right? And then you will specify that these are excluding the temporary loans. So in addition, you can also borrow temporary loans. So you will have to specify these things. You have marks for them. These points will be given in your suggested answer. So you understand how you are supposed to write the answers. You will have to go round and round and encompass everything that is given in the provision. You will have to specify that okay, 1 crore 5 lakh is the limit, but even if you want to go beyond, please go for temporary loan. That is allowed, right? And then you will also write that the secured loan that we are talking about is not a temporary loan. That is our assumption. Because if that was temporary loan, we would not have considered it at all. So our limit would be 1 crore 35 lakhs. So you will have to specify these small things, right? The next question you have is from the CA Final May 2007. Now this is a different question. First of all, this deals with your clause A. That is the difference. And second, it is a little tricky than the question that you have already been doing. Now over here there is a twist, right? So what happened is that your article provides that the board has the power to sell off their undertaking, right? Whole or substantially hold, whatever it is, they have the power to do it. Yeah, obviously we know that if they are going on beyond 20% limit, if it is a substantial undertaking that they are selling, then they will have to seek the resolution of the members, right? We know that. But let's keep that aside. The question is not talking about it. What the question is saying, that the board has not thought about anything so far, but the shareholders want to sell off an undertaking, and so they pass a special resolution and they ask the directors to sell off one of its undertaking, right? So you have two things. The article has already given the board the power, and the shareholders have also passed a special resolution to sell off an undertaking. But now what happened is that the board of directors refused, right? And when they refused, the shareholders contended that the shareholders were the principals of the company, right? And the directors were merely their agent and were bound to give effect to their decisions. Is it so? Are directors the agent of shareholders? Did we study anything like that? No. So that is the fact of the question, and now they ask you to decide whether the contention of the shareholders are correct. So you know the answer very well, but now you have a pattern of writing your answer. There as per section 180 subsection 1 clause A, this is the provision, right? So over there, as per the provision, it is clear that the board cannot on its own sell off or dispose substantially whole or substantially whole of the undertaking, right? But the sale of undertaking requires at the first place the approval of the board of directors and then the special resolution of the members. But since in the given question, right, you will also now jot down the facts of the question, and then you will write that in the given question, the fact of approval of the board has not come so far. So if the topic has not been raised by the board, how can the shareholders approve it? The board has not asked for their approval. So in the first place, what is required is the resolution of the board. If that has not passed, the shareholders' resolution is simply of no use, right? It is invalid, it is void, it has no value at all, right? So you will write that such special resolution does not have any force of law. So the contention of the shareholders are not correct, and hence the members cannot usurp the power vested on the board of directors. That means the power that is given to the board of directors cannot be overridden by the shareholders. So the next question that you have is from the CA Final November 2011. 2011 is not very much deep into your past, but it is a recent question, around 4-5 years back. But you see that with the lapse of time, the complexity in the question increases, right? You had one question in 2007, now you have a question in 2011, whereby you have a clubbing of two sections, right? So we'll see what this question has to say. So again, in this question you have been provided with some data that this is the share capital, reserve, secured loan, unsecured loan, current liabilities. These details have been provided to you in the question itself. And then the question says that X is a managing director and he approaches the bank for loan. Now the bank wants your advice whether the bank should or should not give the loan, right? So before discussing the limits, the first thing that we have to notice in this question is that the money is being borrowed by the managing director. What we have seen in section 180 subsection 1 clause C, that this is the power of the board, right? And then these powers are restricted because you also need an approval from the members in the general meeting, which is a special resolution, right? Over there nowhere we have talked about a managing director. But now if you connect the same question with section 179, right, the previous section, the power of the board that we had seen, section 179 subsection 3 clause D, over there we had read that clause D, E and F are the three clauses, are the three powers that can be delegated, right? The board has the power to delegate these three powers. And whom will it delegate? To the committee of directors, to the managing director, manager, and the principal officer of the branch and the head office both, right? So you will have to specify that section 179 subsection 3 clause D gives you this power, but subject to three conditions. That these are the only people whom the power can be delegated. Second, it will be delegated by passing a resolution in the board meeting only. And third, that these delegations will be subject to certain conditions, right? We have seen that in case of borrowing you specify the limit that is left for borrowing. In case of investment you will have to specify the limit of investment and also the purpose of investment, right? You have seen those things while we were discussing section 179. And then after that you will have to go ahead with writing the provision of section 180 as well, right? And then you will check the limits. And once you have the question on the limits, we have already solved certain questions, so you know what is to be done ahead, right? So this was the only twist, that once you have been talking, once the question has started talking about the managing director, you will have to talk about the same. So you will have to refer to the section where you have seen that the power of borrowing can be delegated, right? You will have to give a reference over there. So we'll discuss the last question, that is from CA Final November 2014. So this is a very small question. Again, obviously you have question on section 180 subsection 1 clause C, right? But the only trick you have over here is you have been given the data as per your accounts, and then you have to decide what will be included in the free reserve and paid up share capital and what will be included in the loan, right? So you have paid up share capital of 100 crores, authorized first you have the authorized share capital of 100 crores, paid up share capital of 40 crores, general reserve of 20 crores, debenture redemption reserve of 10 crores, provision for taxation, remember, for 5 crores, right? Loan that is long term 10 crores and loan that is short term, actually short term creditors 3 crores, right? And the board decides that they want to raise an additional of 90 crores of loan. So what you see over here, that the limit of borrowing made and supposed to be made should be below paid up share capital and reserve if they are to be under the power of the board itself. So your aggregate of paid up share capital and reserve amounts to 40 crores plus 20 crores is 60 crores. And what you have already borrowed is the long-term loan of 10 crores. Short-term creditors and provision of taxation will not be, these things will not be included. We're only talking about the loans, right? And we are not talking about short-term creditors. So it is 10 crores. So out of 60 you have already borrowed 10, so you can borrow a maximum of 50 crores without the approval of the shareholders. But since the board wants to borrow 90 crores, they will have to pass a special resolution. That is all about this question, nothing else, right? So with that we come to the end of section 180. We have discussed the entire provision of the section. We have also discussed the question, right? So that will be the end of the lecture today. We'll continue the provision of the next section with the questions for that section.